Welcome to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we're going to be discussing the situation when there's rumors swirling around in your company that there are potential layoffs coming, people are going to be fired, and there is a possibility that you might be one of the people that might be on the chopping block. So the first thing to do is not to panic. If things are going to happen and if you get laid off, you get terminated from your job, there's really not a lot you're going to be able to do at the last minute. So the reality is what the reality is, and there's no point in trying to say, I'm going to start begging for my job, change my performance in the last few days. Decisions oftentimes have already been made as to what's going to happen. If anything, you just want to maintain a positive attitude. You want to perform in accordance with what the previous expectations were. You don't want to scuttle the relationship unnecessarily. And keep on moving forward. You might actually not be on the chopping block, but you don't want to give them any incentive or excuse to add you to the list if you're not already on the list, or if you're in that contemplated zone of maybe we should put this person on, maybe we shouldn't. Let's see how they're doing relative to other people. The fact is, if the rumors are getting around in the office or at the work site and you maintain a positive attitude and other people who were also in that uneasy position start to act despondent improperly or the like, and let that fear get to them, they might very easily change the decision as to who they're getting rid of and who they're keeping, because sometimes there's initial perspective and then there's somebody more senior who comes and takes a look at stuff and they might reconsider, they might make another decision. If that's the case, it doesn't hurt to be at least maintain an aura of positivity. Thus, even though you might not know whether or not you're going to be laid off or terminated from your job, you do need to start taking proactive action with respect to your position going forward. And yes, this includes prepping up your resume, getting ready, starting to look for a new job, getting your skills in order, and so on and so forth. But from a legal perspective, you need to start planning and protecting yourself and considering where you are relative to completing your position with this current employer should it arise. So one of the things that you should be considering is speaking with experienced legal counsel as to the specific steps that you should be considering and taking to best position yourself with respect to a pending termination or layoff from your job and how you should approach it. Because what is going to happen is you're going to get called into a meeting and you're going to be dealing with a very unusual circumstance that is very uncommon to yourself. At least we would hope is uncommon to yourself. However, the person sitting across from you, typically a human resources individual who has considerable experience in this field, is sitting across the table from yourself, understands what their situation, what their role is, and continues to exude the power position that they would exude from somebody who has done this. Their role, this is their role, this is their job. It's a hard part of their job, but it is a key function of their job. So you're coming into a situation where you need to understand what is going to happen, what you should be saying, what you should be doing, how you should be approaching it, how you should be collecting information. And from that perspective, it's important to talk to the appropriate professional in advance, get some tips, get some ideas, get some strategies, do a bit of role playing. Sometimes people don't want to use lawyers, then they should nevertheless role play with other individuals so that they're confident, they know what they're doing going forward. Because you want to approach it correctly, understand what you should be talking about, what you should be asking about, how you should address questions, and the like. And we'll try to address this in some other YouTube videos. Now, another thing that you should be doing is making sure to organize and collect the materials that pertain to yourself. Now, there's a couple different areas, and this is why it's always also advisable to talk to legal counsel before you start doing some of the stuff we're talking about. But what you want to be doing is making sure that you identify what your personal items are, your personal effects, your personal materials. Now, you may want to take them beforehand, or you may want to leave them. If you're planning to leave them, what you should do is at a minimum, you should make a recording or make a memo listing out all the items in your office that you believe belong to yourself. And take either video or picture images with your phone as to those items. Those are your personal items. You want to make sure you have them. Now, we start to get into a bit of some of the grayer areas, but still pertinent. Couple things. Materials of your employment that relate to yourself. Now, stuff that is reflective of your employment relationship with your employer, you want to make sure that you have appropriate copies of those. Now, certain things you might make copies of it, and certain things you can hold on to, and they might well be personal items in effect. This, again, is something that you should talk to your lawyer about so that you're clarified as to what is appropriate to do with each piece of material. Oftentimes, you might just want to make copies, take videos or picture images, just so you have a record of them. You'll also want to talk to your lawyer about any other materials that you should be asking your employer about or your HR representative, even possibly in advance of any meeting. You want to know how to do it appropriately and subtly and legally and have a record of it. Now, that's another key consideration. Another aspect is, especially if there are issues with respect to your work engagement, you want to start doing this early on before you lose access to your emails. Because what tends to happen is a lot of times you're locked out very quickly of your emails. You want to go through your emails and retain copies of those emails which pertain to your work relationship. You want to make copies. You want to talk to your lawyer about how to appropriately do this, but you want to make sure you have a record of it. The problematic thing is afterwards, your employer will invariably lock you out of their email system and not make things easily accessible. And if there are any issues with respect to your employment, which you would have wanted to have addressed, which you would have wanted to bring up to your lawyer in advance of initiating a process with respect to your termination and severance pay or any other monetary demand, you want to make sure you've gone through and made appropriate copies under the direction and guidance of your lawyer as to what is important to retain and how to retain it. This is important consideration because otherwise you're going to find yourself in a hard place. And the other thing is it's going to make it that much more difficult for your lawyer to address the situation in an expedited fashion And when it makes it more difficult for your lawyer, what that means is it becomes more costly for yourself. So you want to avoid the costs associated with it. You want to approach it, identify, take the direction from your lawyer, tell them what keywords you might be wanting to look at, which emails you want to retain, how you go about retaining them, so on and so forth. You also want to engage your lawyer to find out what other information you might need. Are there policy manuals that they should have copies of? How should you go about obtaining them? How should you get that information? Collect it, provide it to your lawyer, provide it or retain it by yourself for safekeeping. These are things you seriously need to consider. And you need to do them appropriately, professionally, diligently, in a manner that doesn't put you in a bad position relative to your employer, even though acting upon the direction of your lawyer will typically be entirely appropriate. There is the off chance that your employer will see your actions are inappropriate given their power position, and thus you want to make sure you're doing things in an appropriate and structured approach that is consistent with the guidance and direction you get from your experienced legal counsel. Meanwhile, you don't want to be doing anything that would suggest that you're trying to trash talk, antagonize, misappropriate, or otherwise do something that is inappropriate with respect to your employer, your employment, and their possessions. If anything, what you might want to do is, if you're going to take stuff from the office in advance of this, maybe videotape what you're taking, outline what you're doing, and have that recorded. You don't have to ever necessarily provide it at the outset to your employer, but here, make a video, you keep it on the side, and then if your employer seeks to misconstrue your actions, at least you have some basis to refute them and take on this position that what you did was appropriate. You were just taking personal items. Here's the video. I was trying to do everything above board. Nevertheless, this is my stuff. This is why I took it. I talked to legal counsel. You're making a big fuss about nothing. And if anything, it's going to come back and burn your employer. At least that is the objective of it. So what you're wanting to do is make sure you're protecting yourself, because as we say in other YouTube videos, your employer is ultimately out to serve their own interests. They have their own financial interests they're protecting, especially with these larger companies. You're just a number, and it's up to you to protect the financial and personal interests of both you and your family. And what we're talking about is small potatoes in perspective of your employers, and oftentimes your employer's big giant pay package and their golden parachutes. But at the same time, oftentimes you don't want to undersell yourself, shortchange yourself, and be in a position where you're forced to take less than what you properly deserve. So what you want to do is you got to plan in advance. You got to speak with knowledgeable legal counsel who can talk to you about the specifics of your situation, of the specifics of the laws in your particular jurisdiction, and how you might best proceed with protecting your interests, doing it appropriately, correctly, in accordance with the law, but out of an interest of protecting your self-interest, your family's interest, your financial interests, and the like. And this is all very important for you to do, because oftentimes, most of the time, your layoff or termination is simply a numbers game that you're being pushed into, and it's not of your own doing. And it's simply now they got to cut here, they got to cut there, and you have to, at the end of the day, be protecting yourself and your family's financial interests. So I hope you found this YouTube video illuminating. It only provides a bit of insight, and we think important insight as to what you must consider and why you need to engage with knowledgeable legal counsel to appropriately undertake this process so that you're protecting yourself and your family. Thanks again.